Hey guys, it's Dad with Dad's Guide to Adulting. I hope you're doing well and that you're having a great day. In this video, we're going to continue talking about estate planning, and we're going to be talking about wills, intestacy, and probate. We'll also be talking very briefly about whether young adults should get a will. As always, keep in mind that Dad's Guide to Adulting just provides general information. This is not legal advice, and if you have any legal questions, you should talk to a lawyer in your own state. These are videos that I'm basically providing to my own young adult children with my thoughts and sharing with others on the internet, but it is not legal advice. So first, let's talk about wills. What is a will and what does it do? A will is a formal legal document in which you spell out your last wishes. In it, you decide who will handle your estate, meaning who will be responsible for taking care of your last financial affairs. That includes collecting all of your assets, like your bank accounts, your life insurance proceeds, your car, etc., paying all your bills, including your taxes or any credit card or mortgage or rent obligations, and then distributing what's left over to your beneficiaries. Depending upon the state, the person who handles that process is either called the executor or the administrator or the personal representative, but they all basically mean the same thing. When I say beneficiary, I mean the person to whom you are leaving what you own, leaving your assets. That's usually your family members. The executor or administrator will have fiduciary duties to the beneficiaries. That basically means that that person has the obligation to act in their best interests and in accordance with what you spell out in your will. If you have minor children, meaning children who are under the age of 18, this document will also spell out who is responsible for taking care of them after you are gone. That person is usually described as the guardian. That obviously is very important. If you have young children, you're going to want to figure out ahead of time who would take care of them in the event that you die, rather than leaving that up to the courts and having your children raised by somebody that you might not approve of. If you set up any trusts in your wills, you would also identify the trustee. So what's a trust? But basically it's a pool of money or assets that's set up for somebody, a beneficiary of the trust, that will be distributed over a period of time and in accordance with certain rules. If you have young children, you may want to set up a trust in your will so that they get some of the distribution at age 25 and then the rest at age 30, which helps make sure that they don't spend it all too quickly when they're young. Other common provisions that you would also see in a will, including family information, listing of your family members and their relationship to you, contact information for them sometimes, a description about distributions that will happen in the event that some of those beneficiaries have died. So for example, if you leave money to your sister, but your sister has passed on before you, that oftentimes is governed by what's called a per stirpes distribution, which basically means her share would go then to her children. There are also things called contingent distributions. A contingent distribution is something that goes into effect if all of your primary beneficiaries are gone. So for example, if you and your spouse and your children are all killed in the same car accident and your children were the ones who were the primary beneficiaries who would get your assets, the contingent beneficiaries now get your estate and everything that you own. So you also would identify who those people are. So who drafts wills? Well, this is very important. There are very few areas where you need to have a lawyer involved, but drafting wills is one of them. These documents are governed by state law that varies from state to state, and they're very specific, and they have very technical rules on how they may be drafted, what they may contain, and how they are signed. If a mistake is made in the drafting of a will, the court may invalidate it, may say it's no longer valid, and that means that nothing in it is binding. And so you want to make sure that that is done correctly. Many people think that you can simply get a will off of the internet, fill it in, sign it, and be good. I will tell you that that's terrible advice. Never do that. You really would want to talk to a lawyer because those wills may or may not be valid. And this is one area where it's very important to get it right. So those are wills. What is intestacy? Well, intestacy is really just the process of dying without a will. If you don't have a will when you died, basically you are described as having died intestate. If you do not have a will when you die, then the distribution of your assets will be governed under state law. They will have rules that spell out who gets things next. For example, your parents, your spouse, your siblings, in various orders depending upon the state. But that's what intestacy is. So what's probate? Well, probate is the legal process in which a court in your state or your county processes your will, determines who the executor or administrator will be, formally appoints that person, and gives them paperwork that allows them to then act on your behalf in handling your estate. If you have a will, the person who was named in the will become the executor, And that person is responsible for filing the important documents in the court, usually called a probate court or a surrogate's court. And each court has its own procedures, but the executor will be responsible for getting that process started. The executor will also file a death certificate with the court to confirm that the person who drafted the will has passed on. If you die intestate, then the court will not have a will that names an executor, so they will then accept applications from other people, usually family members, to serve as the administrator of the estate, and the court will then pick one. The person who becomes the executor or administrator oftentimes needs to post a bond, which ensures that they do the job properly, and if they do not, that the beneficiaries are protected. If you need to get an attorney to help you with that process, they're usually called an estate attorney or a trusts and estate attorney. Again, I highly recommend that you talk to one if you need to get a will. So here's the key question for young adults. Do you need a will? Well, there's a lot of difference of opinion on that. I'm just going to give you my own opinions. Reasonable people can disagree on this. First off, if you are married, you will probably want a will. In most cases, state law will leave everything to your spouse if you die, but that may not always be the case. Once you're married, it's a good idea to have a will. If you have children, you definitely want to have a will, as that document would determine who would raise them when you are gone. If you have significant assets, or if you're lucky enough to be wealthy, you want to have a will. The more money you have, the more important it is to spell out clearly what will happen to it if you pass away. Young adults who don't have much in the way of money or assets, who aren't married, and who don't have children yet may not need a will. If you pass away in that circumstance, distribution of what you own would be governed by state law. Usually it would be going to your family members. If you also have things or assets that you want to go to certain people, you can sometimes draft up just a note for your family members without having a formal will. If you trust them to honor that, then you don't need a legal document necessarily to do that. If you do decide not to get a will, please keep this on your radar screen and don't wait too long. The older you get, the more wealth you build, the more important it will be to have the document in hand. So in our next video, we talk a little bit about what to do if you are appointed as an executor or administrator of an estate for somebody else. For example, if your parents pass on and put you in that role. We'll see you next time. Until then, remember, you got this.